Life Unrehearsed, brought to you by Lianas Senior Transition Support, helping you navigate home care and senior residences.
And welcome back to Life Unrehearsed. Matt Del Vecchio here, specializing in home care, elder care planning, and the senior living industry. Thank you for tuning in, and happy Thanksgiving to you. Hopefully, you're able to spend some time with your loved ones this weekend. And, well, if you can't be with them in person, how about picking up that phone or maybe even doing a virtual call? I'm sure they're going to appreciate it. And you know what? Even if you're experiencing some conflict with a family member, a friend, or a loved one, this might be the weekend where you put your differences aside, perhaps, and be thankful for what you have. I do see this a lot in my world of senior transitions, and it actually leads me into our next segment, because conflicts will happen in families. I see it all the time. And so many conflicts can be resolved if your legal papers are in order and updated. Unfortunately, things like wills and powers of attorney tend to be items that get put aside. It gets put into the category of, I'll get around to it. Well, this happens more than you actually think. More than 50%, believe it or not, of Canadians don't even have a will. 50%. It's a huge number. And that number becomes even larger when you start talking to people if they've updated their will in the last 5 years. Staggering numbers. So as we age, we really do need to update our legal papers. And to help us get back on track, I'd like to bring in notary Tamar Levy, who joins me in studio. Tamar, welcome to Life Unrehearsed.
Thank you so much for having me, Matt. I'm thrilled to be here.
Well, thank you. Such an important topic. It's taken us a while to get you here, but it is really dear to a lot of people, and it can get really confusing. So I'm glad you're here and able to educate and provide some advice for us. And let's start with will. So why is it important even to have a will? 50% is a big number, so some people don't think it's important.
It is unbelievably important to have a will. First of all, it ensures that your wishes will be carried out and that your loved ones are provided for. It'll save them time, it'll save them money, it'll save them stress. You can also, in a will, determine who your liquidator is. That's the Quebec term we use for executor since 1994. And that means you'll have someone responsible for who you trust to liquidate your estate. In other words, when you die, someone has to be responsible for paying all of your debts, for paying any accounting fees when you die, for making sure your final tax returns are done, and making sure that the maximum amount of money goes to protect the people that you love, perhaps your spouse, perhaps your children, perhaps a combination. And also, having a will lowers the potential for family disputes. Make it clear. You want make it clear.
Like we just talked about
exactly.
These family conflicts.
And it also can bring, I know this sounds counterintuitive, but it can be a catalyst for having important conversations with your families. So it actually can bring families closer together. Maybe there's a child who's worried that you don't have a will and you haven't discussed it with them. They're worried you actually talk to them and everyone is in agreement. It can be a beautiful thing in that way.
I really appreciate what you're saying. We call them essential family conversations. We talked about this quite a bit on Life Unrehearsed. And there's this kind of fear or hesitation when, in fact, once you get that communication out there, people are expressing their wishes, it could make life a heck of a lot easier. Now, I'd like to talk about, there are different types of wills, aren't they? So can you just briefly go over what the different types of wills that are out there?
Absolutely. The Civil Code of Quebec recognizes 3 different kinds of wills: a holograph will, a will before witnesses, and a notarial will. They're all 3 legal. Now, the first 2, all of them have their downsides. All of them have pros and cons. The holograph will is a will that you could just right here, right now, Matt, get out a piece of paper and a pencil and write down a holograph will. Okay, you write it in your own hand. You can't use a computer or a typewriter or anything, and you sign it. That's a valid will.
Does it have to be signed in front of someone?
Nope.
Just write it down, put it on
as
paper,
long as it's all in your handwriting. Okay. The advantage to that is obvious. You can do it easily. You can do it anytime. But what are the disadvantages? I'll get to that after. Right. Wills made in front of witnesses. A will made in front of witnesses has advantages also. Oftentimes, these are the wills that you can just, print out something from the computer, fill it out, and then sign it in front of 2 witnesses. Advantages, again, relatively easy, doesn't cost you anything. Disadvantages, it shares some disadvantages with the holograph will. Number 1, and most important, is it has to be probated. What does that mean? After you die, it has to be recognized in court. Now, that procedure is a lot more expensive than actually getting a notarial will, which is the third kind of will.
Interesting.
So while it's easy, it's going to cost you a lot more in the long run. Number two is you're not benefiting from any legal advice. So you might be writing things in your holograph will that are illegal, or you're not taking advantage of any tax benefits. And if you use a will before witnesses that you've just downloaded off the computer, it might have illegal clauses. You don't know what you're doing. Whereas if you go to a notarial will, there are many advantages. Number one, they're harder to challenge. This is because if I were to do your will, Matt, the first thing I do is verify your identity and capacity. In other words, you're going to give me your ID, and when you're talking to me, I'm checking that you understand what you're saying, that you're mentally competent. So that makes it very, very hard to contest. You also get the benefit of a legal professional who's studied this for many, many years. Also, they don't have to be probated when you die. They are immediately valid. And something people don't think about is a notarial will never gets lost. The notary always has to keep the original in a fire-safe vault. Okay? And we issue certified copies. So if nobody finds your will when you die, you just do a will search and you'll find out which notary has it. So but I always say, any will is better than no will.
And here we are talking
Usually.
to over 50% of the population, right?
Yeah.
Without even a will.
Yeah.
Listening to Life Unrehearsed, I'm Matt Del Vecchio, and I'm talking with notary Tamar Levy about getting our legal papers in order as we age. Very interesting what you're saying with the different types of wills. Obvious, notarial will, people tend to think that's going to be a more expensive option, but just mention that probate issue, and it's actually maybe the least expensive option to go. I do want to talk about, we tend to think of wills as we age. However, for families with young children, it's just as important, if not more important, isn't it?
Oh, it is more important, in my opinion. It is more important. Okay, let's start with the basics. In a will, you can name a guardian for your children. Okay, if my husband and I were to die together in a car accident, for example, I want to be the one who decides who looks after my children. I don't want there to be fighting. I don't want the courts to decide. I don't want a third party. I put that in my will. That will be respected. So that's number one. But also, let's just go for an intestate. Intestate is the word for without a will, death. For example, if I were married and had 2 children and then I died, well, 1/3 of my estate would go to my spouse and 1/3 to each child. A lot of people would say, okay, I can live with that. Except when my children are minors, they can't use that. My spouse will not be able to use that money to bring up my children. Okay? It's frozen for my children. It can get incredibly messy. Plus, if your child has assets worth more than $40,000, there's an obligation to report that to the public curator. There has to be a tutorship council that's created, and that tutorship council has to oversee and verify that my husband is not touching my children's money properly. So if my kids need anything like orthodontics, my husband has to get special permission from the tutorship council, potentially even from the courts, and prove that he can't afford to pay for the orthodontics by himself.
Yeah. So again, like you said, it's probably more important for young families and where you are going to need that. Now, very quickly before we head out to traffic tomorrow, I'd like to, common law relationships are very common in Quebec. What happens if you're in a common law relationship without a will?
If you're in a common law relationship without a will, the relationship is not at all recognized. In other words, you're in a common law relationship, you own a home together, congratulations, you are now co-owners with your in-laws, so to speak. You do not get to share in the house just because you live in it together. You might have 12 children together. Still not recognized by law. You still don't get a penny.
Just amazing what you just said, and I don't think many people realize that. All the more reason to get that will done.
Absolutely.
Talking with Tamar Levy, a wonderful notary, providing us with some advice, and obviously very clear that we do need to get our wills. And we're going to talk about other legal papers when we come back from traffic tomorrow, including gets confusing. Power of attorney, protection mandate, homologation. What does all this mean? We need some clarification on that. And welcome back. You're listening to Life Unrehearsed. I'm Matt Del Vecchio, and I'm talking with notary Tamar Levy about getting our legal papers in order as we age. Tamar, we could have a whole show dedicated to this. There's so much to talk about, but we're going to go in a little kind of rapid fire mode here and try to get in as many topics as possible. Now, when we talk about the succession process after the death of a loved one, can you bring us through that process?
Absolutely. The first thing that happens is obviously you have to get some kind of proof of death. So a lot of people will bring me the declaration of death, which comes from a hospital. We can't use that. We need a death certificate from the directeur de l'état civil. If not, sometimes we can do we can do the will search, sometimes with just a statement from the funeral home. Mm-hmm. Okay. And so you get the proof of death, then you get, we will need the death certificate. Then we do a will search. Remember when I said that you can always find a will from a notary, even whether you have a recent will in hand or whether you're sure there's no will, you have to do a will search. You have to get proof that the will that you're dealing with is the most recent will. You do that with the Chambre des notaires and the Barreau du Québec. Then if the will wasn't made by a notary, you have to probate. Right away, start thinking at least $1,500 and another 6-week delay. If the will was made by the notary, you skip that step. Then you have to identify the heirs. You have to close the deceased's account. You open another account for the succession. You move the funds from the deceased's accounts into the succession account. You do the terminal tax returns. So you have to wait until it's tax time, do the tax returns. Then you get the clearance certificate from the government, both levels of government, both federal and provincial, give you a certificate saying you may now, that there are no funds due by the deceased, and you can now distribute all of the assets, and then you distribute it as per the will. So it's a very long process compared to what people expect. People expect, they're like, okay, a couple of months, 3 months, and it'll be done. It's at least a year usually, 12 months to a year. So you really have to, if you have heirs who are anxious to get their funds, you really have to help them manage their expectations because it does not happen quickly.
Yeah, and I can imagine without a will, just add that to the equation. Now, you mentioned something I want to talk very quickly about accounts. And so I've had some situations where joint accounts were frozen when one person died. Is that true?
Well, yes, until December 8th, 2022, that was the truth. But a new law came out which said that if they are, in the case of spouses, joint accounts are not frozen, that that the liquidator of the estate can obtain the assets of the deceased and the other party can take out theirs. If you haven't made a written declaration to the bank about what percentage is owned by each spouse, then it's considered 50-50. So theoretically, if your spouse dies, you can take out 50% of whatever is in a joint account.
Okay, which makes sense, and that is fair. I mean, there's bills coming due and you need access to funds. All right, we're going to switch hats a little bit here. We've talked a lot about wills. I think our listeners, it's very clear, if you don't have a will done, get it done and update your will if you already have one. Now, I'd like to address powers of attorney and protection mandates. Very often when I'm dealing with some clients or adult children, and they have to make some very tough decisions, they figure, okay, I got a POA, no problem, I'm good to go. So first of all, what is the difference between a power of attorney and a protection mandate?
It is so confusing, but the difference is so stark. The power of attorney can be used exclusively when the person who signed it, who gave the power, is mentally competent. The protection mandate is to be used exclusively when the person is mentally incompetent. So it's a stark difference. The reason for that is, if you think about it, in the power of attorney, the administration of your property, you can oversee it. So if I name my husband as my attorney, and my husband, I say to him, can you go get me $500 from the bank? And he takes out $5,000. I can see that. I'm mentally competent. I can see it in my bank account. I can oversee his administration and I can say, hey, I'm revoking this. That's not okay. But if I become mentally incompetent, then there's no longer any oversight. And that's scary for our people who are incompetent. So that's when you move over into the protective mandate. Another important difference between the protective mandate and the power of attorney is that the protective mandate is not exclusively for assets. It is also for personal care. Who's going to make decisions for you if you get sick and you're no longer able to make decisions for yourself? What nursing home are you going to go to? Are you going to go to a nursing home? Do you insist on staying at home and you want personal care? Do you have the funds for it? What about your spouse? What if everything is in your name? Can your spouse continue to use some of your assets? All those things would be considered in a protective mandate.
So the concept there is, while I am apt, I am writing up this protective mandate and I'm making it clear who's going to take care of my affairs, the person to care to finances.
Exactly.
Okay, I understand. Thank you. Now, I want to give a scenario here. A couple, and you see this, Tamar, a couple, and by the way, we're talking with notary Tamar Levy here on Life Unrehearsed, giving some wonderful words of advice about our legal documents. And I want to paint a scenario for you, Tamar. A couple wants to sell their house. One of the two has been diagnosed with dementia for several years now. Can they sell the house with only having a power of attorney in place?
No, they cannot. Because, as I said, the power of attorney is only for when a person is mentally competent. If the person is mentally incompetent, then the house cannot be sold using a power of attorney. You would turn to the protective mandate. And a lot of people get in trouble at that point because the protective mandate must be homologated. That is a process you go through in court to have it become executory, to prove that the person is indeed incompetent.
So you're writing up the protective mandate, but then you actually have to have it executed, or the legal term is called homologated. So there are situations where I think this is my wife's in the real estate business, and this has happened to her on several occasions where unfortunately one of the two is considered cognitively inapt, and they can't sell their house because they have to go through that process of homologating that mandate.
Exactly.
So the power of attorney is not good enough in that situation.
Exactly.
Okay. Very quickly, Tamar, Loi 18, Law 18 came into effect about a year ago, November 2022, and there was a different shift of ideologies and perspectives. Can you tell us a little bit about this Loi 18 and how this affects Quebeckers?
Sure. It is the law to better protect vulnerable persons. The new regime is more personalized and adaptable to each situation and safeguards the autonomy of the people concerned while considering their wishes and preferences. The goal, I believe, was to provide individuals the ability to exercise any civil rights that they could insofar as possible. And it's changed a lot of things. For example, we used to have 3 levels of care for people who didn't have mandates and were incompetent. You had advisors to people of full age, you had tutors, and you had curators. There are no longer curators anymore. Now there's tutorship, which is modulated. What does that mean? That the court is now looking at about 6 different things, 6 different acts, and saying, okay, you're incompetent for this, but not for that. And those things are, for example, voting, guardianship, the power to make purchases for their usual customary needs, to sign a lease, acts relating to the person's work or profession. Sometimes people who are incompetency is a spectrum. It's a scale. It's not a flip of a switch on and off. So sometimes people can be incompetent to one aspect of their lives, but not another. And this law, definitely the goal is to respect that.
I love that. And that's a big part. And the legal people that I've talked to and clients, Loi 18 is not making it black and white and recognizing the rights of Quebeckers, even though if they are having some challenges, it doesn't necessarily mean that they're totally incompetent or inapt. Okay. You know what? We have to. We're already out of town tomorrow. Okay. But I really do want to thank you for coming in on a Sunday here, and such valuable information. And I think the message is very, very clear. If you haven't looked at your legal papers in a little while, it's time to do that to protect yourselves.
Rule of thumb, read them every 5 years, and every time something big happens. You don't necessarily have to redo them, but read them. You might be surprised what you wrote in the past.
Very good advice. Thank you very much, Tamar.
Thank you so much for having me, Matt.
All right, that's Tamar Levy, a wonderful notary and wonderful words of advice. Well, thank you very much for tuning in to Life Unrehearsed. And as a reminder, for all your inquiries or assistance with life transitions, elder care planning, in the senior living industry, it'd be my pleasure to help. You could find out more if you look up Lianas Senior Transition Support. That's Lianas, Lianas, Senior Transition Support. Next week on the show, we're going to be talking about concierge services for older adults, yoga for anxiety, and the increasing role of our local pharmacists for our overall health and well-being as our healthcare system begins to show its cracks. Many thanks to our technical producer, Dario. Great job today. Happy Thanksgiving, everyone. You can listen to Life Unrehearsed here on CJD 800 every Sunday at 4 p.m.